The paper is Law Reform Without Legislation, Sentencing Guidelines as a Case Study. We're very fortunate to have as our commentators His Honour Judge Martin Picton, who is a circuit judge and a judicial member of the Criminal Procedure Rule Committee. Sitting next to me, of course, Professor Lorraine Gelsthorpe, Deputy Director of the Institute of Criminology, Director of the Centre for Community, Gender and Social Justice at the Institute of Criminology, and somebody very well versed in sentencing law. Our paper is being presented, of course, by Professor Julian Roberts at Worcester College, Oxford, formerly member of the Sentencing Council, and obviously somebody with a very great deal of experience in sentencing law. And we are delighted that he's attended today to present his paper to us. So without further ado, I'll invite him to do that.
Just one correction, I'm still a member of the Sentencing Council, so let me just issue a disclaimer. These are my personal views, not necessarily those of, I was going to say, any sentient human being, but they're not necessarily the views of the University of Oxford or the Sentencing Council of England and Wales. So I'm very honoured to be here and very grateful to the organisers for the invitation and to Judge Picton and Professor Gelsthorpe for taking the time from their onerous judicial and academic duties to comment on the paper. There is a paper which obviously they've read. There's an outline floating around somewhere, and if anyone feels that there's sufficient interest to see the longer paper, please just email me. And finally, I'd just like to say I'm honoured to be on the same panel as Professor Jeremy Horder, such a leading figure in criminal law. And we overlapped at Worcester College for several years before he was regrettably lured to London. But it is an honour. So I was asked to consider the English guidelines, I call them English guidelines for the sake of brevity, the guidelines applicable in England and Wales within the context of what we might term soft law approaches to law reform. So I think that envisages a kind of a dimension from soft to hard, or a hierarchy from hard down to soft. And I suppose we'd put at the top legislation, primary and secondary, and we'll come on down at the bottom, or at the soft end we would have guidance of various kinds, CPS guidance, DPP guidance, practice directions and memoranda, moving along a bit, criminal procedure rules, and somewhere in this we situate the sentencing guidelines. But I think it's hard to pin them down, and I think they're somewhat unique. I think I would place them beneath primary and secondary legislation, but sort of above legal judgments, because of course all courts must follow in this jurisdiction any relevant guideline, unless it would be contrary to the interest of justice to do so. And of course that includes the Court of Appeal. And so what's the status of these guidelines? Well, there's a statutory duty on courts to follow them. And I think there are some complex constitutional issues to consider. I won't consider those today, but at a conference recently in Cyprus, there was a number of judges raised some objections to the notion of guidelines in that context. And so that's a discussion which I think still needs to be held. But as I say, I will place them in the middle of this dimension. And I suppose there's a strong and a weak version of my contention. My weak argument, a weak version, is that guidelines supplement traditional sources of guidance from the Parliament or from the courts. The strong version is that you need guidelines. They're not useful, they are necessary to achieve principled sentencing. They fill a gap. So you may say, well, what's the gap that's being filled? And I think it's the gap between legislation and legal judgments. And the gap reflects the limitations of both sources of guidance. So legislative guidance, let's talk about that for a minute. I think it's a pretty crude and ineffective way of achieving reform. Former Lord Chief Justice famously stated that we needed a moratorium on sentencing legislation. And one has to question, I think, with respect, some of the legislation in the area of sentencing that's come along in the last few years. I'll just take a recent example. We've had over the last few years amendments to the maximum penalty structure. So, for example, the maximum for stalking has been raised following a proposal put forward by 2 MPs. Rory Kelly at Oxford, one of my colleagues, is doing some interesting work on this, and I'm grateful to him for bringing that issue to my attention. I think the problem, I'm not going to make any comment on whether the maximum for that offence should go up or down or stay where it is, but the methodology, I think, is a little suspect, because if you are going to tinker with or amend the maximum penalty for a particular offence, you need a comprehensive proportionality analysis. You need to look at other comparable offences, other offence categories, and that's very seldom done. On that particular issue of the stalking maximum, there was a limited comparative analysis done, but it was to acquisitive offences, to make the point that stalking attracted a pretty low maximum relative to these acquisitive offences. Not the most appropriate comparator, I wouldn't have thought. And of course there are many other examples of sort of ad hoc, periodic, potentially populist amendments to the statutory penalty framework. Now, we're just about to mark the 40th anniversary of the Advisory Council on the Maximum Penalty Structure. Old-timers like myself will remember that. And I think it's a good example, the maximum penalty structure, of an issue that needs a robust, detailed, comprehensive and integrated, holistic, a lot of adjectives there, analysis. And it's not something that can be accomplished by 1 or 2 academics or 1 or 2 MPs. It's a job for the Law Commission, or a job for the Sentencing Council, or a job for the 2 of them together. It needs to be comprehensive. So that's just one example. If you want a second example, I think it's even more flagrant. Anyone here consider that the Schedule 21, which affects, obviously, shapes sentencing for murder, did that make murder sentencing more principled? Jonathan Bild is here somewhere. Dr. Jonathan Bild did a DPhil on this, and Mepsi will jump in on that issue in the questions. So I think, again, an example of not a particularly principled intrusion into the exercise of judicial discretion. And I think these examples show the limitations of legislative intervention. Barry Mitchell and I at Coventry have long been arguing for a guideline on sentencing murder, and the response is usually, well, we have Schedule 21, to which our response is, that's right, we need a guideline. So there's a lot to be said there. But so these are the limitations of legislative intervention. I think we could go on. Of course, these arguments don't apply to legal judgments, the judgments from the Court of Appeal, because now we're talking about a principal response. We're talking about a careful, deliberative reflection by senior judges, guided by precedent and submissions and so on and so forth. But of course, there are limitations on the guidance that can come from the Court of Appeal. The issues coming up will be party-driven, and many people have, over the years, commented on the limitations of appellate guidance. I'm not just talking about England and Wales. In fact, we're not really talking about England and Wales in that example, but around the common law world, Australia, Canada, a jurisdiction I'm familiar with, New Zealand. Not much guidance from the Court of Appeal on a range of issues, and I'll come back to that. So that's the gap that's being plugged or filled by the guidelines, this politicized, questionable, potentially unprincipled intervention by Parliament, interventions by Parliament, and legal judgments which come along from time to time. May not be comprehensive enough. Excuse me. So what I'd like to do in my few minutes is just give you a series of 5 or 6 examples where I think guidelines can make a difference, how they can plug that gap. And I'll talk about, first of all, about sentence reductions for a guilty plea. Now, again, and I'll broaden this to other jurisdictions a little to illustrate the wider benefits of guidelines. So in Australia or Canada, they don't have guidelines for offences or issues like the guilty plea reductions. It's down to judicial discretion. In fact, the Ontario Court of Appeal, which is probably the most important of the 10 Canadian Courts of Appeal, has taken the position that it is inappropriate for an appellate court to provide guidance as to the appropriate level of reduction to be awarded defendants who enter a plea. That's for the exclusive discretion of the trial court. Now, okay, so that's one position. In England and Wales, of course, we have the statutory provision in determining what sentence to pass, etc. A court must take into account the stage in the proceedings and the circumstances in which the indication was given. We all know the provision. That's not particularly helpful. You need some kind of a scale, I think. Without a scale, there's no consistency, and more importantly, there's no incentive. So we have Cayley, and Cayley, of course, endorses this notion of a scale, and I'll just quote Cayley. It's obviously desirable for there to be a baseline of broadly consistent approach if justice is to be done in all parts of the country. Equally, such consistency is necessary if proper advice is given to accused persons. So, absent a guideline, or absent some clear indication of the levels, 1/3, 1/4, 1/10, whatever you think of plea reductions, and of course it's a contentious issue, some people oppose them, people have expressed important concerns about vulnerable defendants, about the magnitude of reductions, the impact upon proportional sentencing, and so on. But if you're going to run a regime of reductions, they need to be clear, relatively predictable, and transparently developed. And so the guideline came in 2004, revised in 2007, and again in 2017 by the Council, and there it is, the latest one. And I think we are in a much better place. I think it's the point I make in the paper that solicitors are much better placed to advise their clients in this jurisdiction than in a jurisdiction where levels are not apparent in a guideline. So that's the first point, or the first example I'll give you. The second is another sort of cross-cutting or cross-jurisdictional issue, and that's starting point sentences. So starting point sentences have been an element of appellate jurisprudence around the common law world for many decades. I think the first starting point sentence was probably judgment in Canada was probably Sandercock, that's going back about 40 years. But what is a starting point sentence? The starting point is a nice way of orienting all courts. It's a point of departure. It's a common reference from which they will then move, in the case of a guideline, to work through the steps of the guideline. But I think it's important, if you're going to have starting points, that they be robustly determined. How does a Court of Appeal determine a starting point sentence if it's issuing a guideline with a starting point? Well, it'll consider the matter, it will reflect on the proportionality of the offence, seriousness, harm, it'll look at precedents, analogous offences, and that will be it. But a starting point sentence as determined by the Sentencing Council, I think, is a more robust affair. So, the offence-specific guidelines, like assault, burglary, and so on, they all have category ranges, and each category range carries a starting point. Where does the starting point come from? A deliberation by counsel initially, an analysis, multi-year, comprehensive, multi-level analysis of sentencing statistics, a careful review of the case law, especially appellate case law, an examination of ancillary, related, analogous offences, an overall proportionality review for offences of which there are varying degrees of seriousness, any relevant research which might shed light on where the starting point should be, and so on. It's a more robust situation. And then, of course, the starting point is issued as a consultation guideline, and we have feedback from practitioners, judges, interested parties, and so on. There'll be another reflection by council once the responses to the consultation are in. We will then reissue the guideline, or issue the guideline as a definitive guideline. I think that process is a bit more robust. So that's my second point. The third advantage or potential utility of guidelines is to correct some misapplication of a particular disposal. I'm very pleased that Sir Anthony Bottoms is here today somewhere. Where is he? Sir Anthony. So, the use of the suspended sentence order, 1981, Professor Bottoms published a seminal paper in the British Journal of Criminology, noting that the suspended sentence was being misapplied. It was being applied to high-end community orders. And I think, Professor Bottoms, correct me if I'm wrong, there may even been some indication of this even earlier than your paper, but your paper obviously put the issue on the map. So how do you correct that? Well, there's been no statutory reaction to that. Here we are in 2017, and the Sentencing Council was aware of this misapplication. It noted a vertiginous rise in recent years of the suspended sentence orders and a declining use of community orders, and it recognized the research by Sir Anthony Bottoms and many other academics since, I might add, and it concluded that a potential reason for the increase in the suspended sentence order and the concomitant decrease in community orders was that in some cases suspended sentences are being imposed as a more severe form of community order where the offending has not crossed the custody threshold. I'm quoting from the consultation document issued by the Council when it issued its draft guideline on the use of different disposals. In light of this, the Council considers it important to clarify the circumstances in which the suspension of a custodial sentence may be appropriate. So it's attempting to correct that misapplication in certain cases by courts, and I think that's a useful additional way in which it's sort of plugging the gap. Now, we still don't know. The new guideline is relatively new. We don't know the extent to which it's had this salutary or corrective effect, but I want to put that on the table for you. Next example, whistle-stop tour, re-establishing proportionality. When the Council was looking at the drug offences guideline, it observed and conducted research and concluded that sentences for drug couriers, lower-level drug couriers, mules, as they're sometimes called, was excessive, was disproportionate. So it departed from its usual procedures, which is to reflect judicial practice when issuing a guideline, and it decided to refract judicial practice somewhat by lowering the sentences for drug couriers, rendering them more proportionate. And that, I think, is a salutary change. Now, some people may disagree with it, and that's why it's good to have the consultation. But that's been demonstrated to have had a change in judicial practice. So sentences for that profile of offender have changed, and in a relatively short space of time. The Council is currently, as you know, consulting on its draft terrorism guidelines, and they may change judicial practice for a certain profile of cases. And again, there'll be conflicting views as to what Council should do, but if there is a settled position and a consensual position, then the guideline is an expeditious vehicle to effect change of judicial practice without waiting for a judgment from the Court of Appeal or legislation. So guidelines are a dynamic model. I think that's what I'd like to stress. They can move more nimbly than the Court of Appeal and can affect change more expeditiously. The next point I'd like to make, democratic accountability and transparency. These definitive guidelines reflect judicial practice. I'll list a few things. Judicial practice, empirical research, public opinion research, see where the public sits on an issue, stakeholder, practitioner input, parliamentary scrutiny, parliamentary input through the Justice Select Committee, and of course the minutes of the meeting are published and the documents are made available on the website, So there's a transparency, I think, and sort of accountability that otherwise would be lacking. Now, you could say, well, we could do more. The council could do more. And I'll just put on the table the example of the US councils, commissions. For example, the Sentencing Guidelines Commission in the state of Minnesota conducts all its hearings in public. If 2 or more commissioners would like to talk about a particular issue, they are obliged to call a public meeting. So you can just show up and hear the commission deliberate. And in fact, if you sign the register at the beginning of the meeting, as I have, at the end of the meeting, you can stand up and address the commission. And you can make some submission on some element or issue in their area. So I think the transparency and the public-facing consultations and so on open up sentencing to quite a degree. The next example is a little outside of sentencing practice, but it's another utility of guidelines and a council. Public attitudes to sentencing is an area I've been working in for about 30 years. What do we know? The Crime Survey of England and Wales, formerly the British Crime Survey, routinely shows 70% of the British public are critical of courts, sentences are too lenient, judges are out of touch, and so on and so forth. And that's because, of course, the public picks up a newspaper and they read some inaccurate account of a sentencing hearing or decision. But I think guidelines can play a role here, and I'll give you an anecdotal example and a research example. The anecdotal example is the case of the Oxford medical student this summer, many of you may have read about. She came from quite a wealthy background. She was apparently a brilliant student, and she was convicted of stabbing her boyfriend in a sort of drug-induced frenzy, and ultimately she was spared a term of immediate custody, and a lot of newspaper headlines were very unhappy with that. A lot of people were very unhappy with that, and there was tales of, Oxford student, Oxbridge trained judge, all these sorts of things. Here's an example of a headline. Oxford student who stabbed boyfriend spared jail, quote unquote, because of her extraordinary talent. Not because of any sound judicial reasoning, but because of, she was a very good student. Not Worcester College, I hasten to add. So the Secret Barrister had a nice analysis of the judgment when it was published, working through the guidelines, showing how the court arrived at this decision in a very reasonable and consistent approach. And in fact, the Times, some of you may have seen it, had a lengthy article saying, let's look at this sentence and let's start with the guidelines. I think that's a useful way of reminding the public that it's not a single judge just cooking up a sentence out of his or her head. So that's an illustration, a nice illustration, I think, of how the media could place sentences within some context. Here's the research example. So we did a little experiment, not a little experiment, we took a representative sample of the British public, and we created 2 groups, and we asked both groups their opinion of some sentences for burglary, robbery, and benefit fraud. Half of them were given a brief description. They were all given a brief description of a case and told the sentence. And the dependent variable, or the question for the public, was simply, do you find that sentence too lenient, too harsh, or about right? Now, most of the time when people are asked questions like that, they say the sentence was too lenient. The other group was asked exactly the same question about the same case and the same sentence, but we just gave them a little paragraph about the council and its guidelines. There's this thing called the Sentencing Council. It issues guidelines. Courts must follow these guidelines unless it would be, and so on and so forth. So considering the same sentence, with or without context of the guidelines. Without the guidelines, 57% of the sample thought the sentence was too lenient. 36% thought it was about right. So about 2/3 are dissatisfied. The group with the guidelines, the group that had read the guidelines first, had a reversal of that reaction. 58% of them thought it was about right, and only about 1/3 thought the sentence was too lenient. So just putting it into a context, I think, and that's been published in the British Journal of Criminology, peer review and all that sort of stuff. So I think this is a benefit, a potential benefit, it's just one study, potential benefit of the guidelines that we shouldn't overlook. I think I'm running out of time. I'm just going to take 2 or 3 minutes just to give you a flavour for the peer review research that's been conducted on the guidelines. Of course, the Council has conducted research on its guidelines, but it's generally speaking research that's looked at whether our projections of the impact of the guideline on the prison population or prison places is accurate or not. So we produce a guideline and it's designed to be resource neutral, and then after the guideline comes in, has it increased the prison population, or is it likely to, or was our projection accurate? The Council hasn't done so much in terms of consistency in related matters, but a number of peer review researchers have done that. And one of these studies is a study by Professor Jose Pina Sanchez at Leeds. And I'll just read you his conclusion. He did a detailed analysis pre and post introduction of the assault and burglary guidelines, looking at consistency before and after, drawing upon the Crown Court Sentencing Survey, which is that wonderful survey of judges, the only survey in the world ever in which sentencing statistics data have come from the sentencing authority rather than from somebody coding case files. So, pre-post, what changed? The level of I'm quoting, the level of consistency in sentencing was higher than found in previous studies, and that's a sort of an interesting finding, because the previous studies by the Ministry of Justice and the Home Office before that showed quite a bit of inconsistency in sentencing in England and Wales. But here's a key finding. Consistency in sentencing improved after the new guidelines, regardless of the method used to assess that change. The majority of measures suggest detectable increases in consistency after the new assault guideline came into effect. So I think that's encouraging. Other research on the burglary guideline found that the factors were being consistently applied across courts. I think that's encouraging. And lastly, there have been some critiques of the guideline which are amenable to empirical test. So one of the critiques I quite often hear is sentencing has become a box-ticking exercise. It's categorization and so on. This is reminiscent of the American grids and so on. And we're losing individualization. Personal mitigation is being squashed down. People pick up, they look at the factors that need to be ticked for the court's attention. Well, you can test that. So we did. We looked at, using that Crown Court Sentencing Survey, at the number of factors reported before and after the introduction of the guideline, and we found more factors being cited after the introduction, not fewer as you might predict, and greater individualization after the guideline compared to before. Now, a number of people, Nicky Padfield and Rob Allen and Professor Bottoms, have made the point, and I fully agree with them, that we need to know more. The research record is insufficient. But my conclusion, and I'm keeping my academic hat on when I say this, is that the results to date are encouraging.
I'd say that I think all of Professor Roberts' paper, which I've read, provides an insightful and informative analysis of the current situation, with which I have to say I agree. I am someone who works at the coalface, as it were, actually utilising the guidelines, and I assess them as having successfully produced a beneficial degree of consistency, in large part because of the evidence-based process that is the foundation for their formulation. The credibility thus generated has produced a very substantial buy-in on the part of the judiciary. I can still remember the times when sentence seemed pretty much based on judicial feel and gut instinct, and mitigating the old days was certainly a rather more adventurous process for the advocate, because you may have absolutely no idea what sort of sentence a judge might be contemplating, save if you knew the judge or had some knowledge of their reputation. That level of uncertainty was perhaps one of the factors that gave rise to the introduction of the Goodyear indication system, which I'm assuming all of you will have heard of, whereby an inquiry can be made on behalf of a defendant contemplating the possibility of pleading guilty as to the maximum level of sentence the offender might expect to receive if they were to do so at that particular time. So far as offences for which a guideline now exists, the Goodyear system has, or it may be thought should have, become pretty much redundant, and certainly my impression is that in such cases the frequency of applications being made has reduced. So given that one feature of the work undertaken by way of creating guidelines is to look at the current levels of sentence, I do not perceive that judges generally feel that they are being steered away from a length or type of sentence that they would have contemplated but for the guideline. I've certainly been involved in road testing of guidelines, which is an aspect of the consultation process undertaken prior to a new guideline being finalised, and I perceive it to be a genuine consultation process. It is not just paying lip service to the idea that there needs to be a consultation in circumstances where in fact the council is already of a settled view of what it's going to do before that starts. Over time, the respect in which the guidelines are held by judges has grown, and my perception is that there is a substantial level of judicial satisfaction with them. They are regarded as being fit for purpose. And I have some range of experience of judicial views because I happen to be the director of the Serious Sexual Offences Seminar. So annually I meet about 320 plus judges on residential courses, and sentencing is one of the areas that I train on and we discuss, and it involves working through practical sentencing scenarios, applying the guideline and analysing how it operates. And as I say, my general view is it assists, and judges like them and they find them helpful. In the course of Professor Roberts' paper and his words just now, he mentioned the potential for the guidelines to be used as a tool that could either increase or decrease levels of sentence, although that obviously isn't their stated purpose. From what people have said to me, there is perhaps a view that, for example, in the area of sex sentencing, sentences have gone up substantially in the last 2 decades. And I'm not suggesting that's a bad thing, it just happens to be something that appears to be the case, and there are going to be a range of reasons why that should be, not least by reference to the increase in the maximum sentence for many sexual offences. But the landscape's changed so far as that particular type of offending is concerned and the way it is perceived by the public, and the guidelines must have played a role in that in the course of the publication of the first one in 2007, the second one in 2014, and we are where we are. What factors have contributed most substantially to that is a matter perhaps for research and debate. The guidelines have brought about a very substantial change in the work of judges. I can certainly recall the days when sentencing consisted of a few terse remarks, often expressed in a manner of faux outrage. Stand up, Jones, you're a filthy piece of work and a disgrace to humanity. 10 years, take him down, seemed to be reasonably commonplace. It was then, and at times still is now, a challenge to get a judge to trouble to say from what sentence he had discounted to reflect credit for plea, let alone analyse the mitigation as might have been urged on the offender's behalf. And that former style of sentence pronouncement lacked the credibility that can now be identified in our sentencing process by reference to the use of the guidelines. In the past, we were all used to working with guideline cases, but as Professor Roberts identifies, as a sentencing tool, a guideline case is always going to lack the capacity to assist in the very wide range of sentencing circumstances that guidelines promulgated by the Sentencing Council can better accommodate. The language of sentencing has changed fundamentally since the guidelines were introduced. Sentencing remarks, a bit like Court of Appeal judgments, now take a good deal longer to deliver. I recall one of the early judgments in an appeal against the sentence of IPP where, if I recall the case correctly, a young female robber who had committed an offence that didn't even involve the threat or use of a weapon ended up subject to an indeterminate sentence, which, for all I know, she's still serving, despite the minimum custodial term having expired many years ago. And the Court of Appeal, in the course of upholding the sentence, did at least suggest that the recorder could perhaps have let the offender sit down during the 25 minutes it took the recorder to outline the reasons for the sentence. It is, of course, crucial that judges set out the reasons for the sentences that they pass, and when those reasons are based upon necessarily complex sentencing guidelines, it is going to involve a rather more lengthy exercise than of old. Detailed explanations for the reasoning behind a particular sentence certainly benefits the public. Those reasons also benefit the tribunal of potential review, and they are possessed of a crucial level of transparency. How much some of the detail interests the offender, who either cannot follow them or does not have any interest in so doing, is perhaps another matter. For some offenders, the only interesting bit is the nature of the sentence, and most crucially the number of months or years announced at the end of the process. As Professor Roberts' paper identifies, sentencing remarks do have to address more than one audience, notwithstanding the statutory imperative to express it in terms that the offender has some prospect of understanding. And I certainly gave up requiring offenders to stand for any part of the sentencing process many years ago. Professor Roberts references how guidelines can at times be used as a shield by judges behind which they can seek to hide when passing what they may perceive to be potentially unpopular sentences. That is particularly so perhaps with offences such as death by careless driving, where there is an inevitable disconnect between the level of culpability, the degree of harm done, and the sentence that results. Infelicity in the construction of sentencing remarks can provide fertile ground for those seeking to pursue an appeal. In the recent case of Bush, the Vice President had to point out the need for judges not to misuse the term starting point, a term of art in the guidelines, by way of applying the reduction reflective of the relevant credit for plea to a period so termed. The concept of starting point does rather carry with it the implication that you have to do rather more by way of adjustment before you apply whatever percentage degree of credit for plea the case demands. Judges have developed a tendency to use starting point as shorthand for the sentence the offence merited prior to the application of credit for plea, and that said, it is a shorthand that could at times be found to be being used in judgments of the Court of Appeal, so it was not simply a first instance bad habit. I do think that judges of 20 or more years ago would be amazed at the length and detail of sentencing remarks today. Such sentencing remarks are, however, surely better than the judge simply identifying where in a Minnesota grid-type tool the offence falls with a consequent computer says no result, where in fact the case calls injustice for some other disposal. The use of the guidelines provides a sentencer with the necessary reminder of the importance of the exercise as well as its complexity. Sentences should not be imposed at the whim of a particular tribunal, subject only to the potential correction by an appellate tribunal, should the lawyer be clever enough to think up a decent argument. So I'm probably overrunning my time, but just to give two practical examples of what I perceive as real benefits of sentencing guidelines. I mentioned two cases I dealt with this year, both of them drugs cases, both of them undercover operations. In the first one, there were 90 defendants. I had to sentence 90 defendants, all caught up in the same drug operation. You can imagine just what a nightmare that would have been without the guidelines to assist, with myself having to fall back on cases such as Twiss, Dargit and Afonso, if any of you remember those, and what they had to say about how courts should deal with drug dealing cases. And the second one, another similar operation, 60 defendants, but engaging the process of cuckooing, which again you may have heard about in the press recently, a relatively recent phenomenon, recent enough to have developed since the drug guideline, most recent drug guideline was formulated, and which required Lord Justice Tracy to address as a separate and distinct topic by way of explaining how the guidelines applied in such circumstances. In the case of Ajay and Limby, if you've heard of that, cuckooing is where drug criminals from the cities take over the homes of the vulnerable or use the vulnerable to ply the drug trade out of town and at a safe distance from themselves. it is critical to the job of applying the guidelines to recognise that they are just that. They are not tram lines, and a mechanistic approach to their application has the obvious capacity to do real injustice. The guidelines do have a substantial degree of flexibility built within them. A great deal more, it might be thought, than such measures as minimum term sentencing or the original concept of presumed dangerousness as the 2003 Act brought into existence. I don't think there are many who now suggest that that latter measure was anything but a disaster. The guidelines provide scope for individualism in sentencing whilst imposing a proper discipline of analysis and explanation that was frankly absent in the past. Some broad level of anticipation of result in respect of the sentence that may be generated by particular offences is obviously beneficial, as long as the sentencer retains an understanding of the degree of wiggle room that remains in an appropriate case. There is always room to wiggle.
I'm very pleased to have had the opportunity to both read and hear a summary of the paper just now, and I think Professor Roberts makes some very important points about the benefits of the Sentencing Council guidelines as a soft approach to law reform. I should declare that I am not a lawyer, and so I may have missed some of the finer points, but as a criminologist who takes a strong interest in sentencing matters, and as someone who teaches aspiring lawyers, I value his careful appraisal of the guidelines. As it happens, I've been teaching undergraduate lawyers this past week, students who are doing a course in criminology, sentencing and the penal system, and in small groups they go through a sentencing problem or two, and it's very interesting. This is a small sample of 25 students in small groups. Very mixed views. Half of them suggest that there's too much discretion within the guidelines, and the other half think that there's too little discretion within the guidelines. But a common feature was their confusion about Section 2, particularly in relation to the guidelines on assault and burglary, which I think mirrors Sentencing Council research, previous research. So Professor Roberts asks us, are we any better off as a result of having the definitive guidelines? I think it's a very good question. The guidelines have some advantages, but I don't think we should downplay their disadvantages and their failings. I would rather have them than not have them, but I think there are many challenges within. So rather than pick up on specific legal points, I want to offer some general comments on the tenor of the guidelines and where they lead us. So my comments revolve around interpretation and implementation. So I certainly think that we have more consistency, and I think that sentencers seem to like the comfort of the guidelines. But I want to say, let's just look at the prison figures, the state of our prisons, the current use of extended sentences, the recall rate, the cost to the system. Yes, judges are meant to take into account cost, of course. And, for example, the findings of the recent Lamy report, an independent review into the treatment of and outcomes for Black, Asian and minority ethnic individuals in the criminal justice system, and the racial bias, quoting David Lamy here, writing in The Guardian on the 8th of September, the racial bias in our justice system is creating a social time bomb. And David Lamy says, when David Cameron asked me to conduct a review into the overrepresentation of Black, Asian and minority ethnic individuals in the criminal justice system, I thought I was being set up to fail. So many of the causes of and answers to the problem lie outside the criminal justice system. I think everyone would recognise that. David Lamy goes on to say, having looked at the evidence over the past few months, my judgment, again quoting, my judgment is that we have a significant problem in the criminal justice system itself, and that the treatment of Black and minority ethnic young people in particular shows that this problem is getting worse. So despite making up just 14% of the population, Black and minority ethnic men and women make up 25% of prisoners, whilst over 40% of young people in custody are from black and ethnic minority backgrounds. If, again this is David Lammy speaking, if our prison population reflected the makeup of England and Wales, we would have over 9,000 fewer people in prison, which is the equivalent of 12 average-sized prisons. There is greater disproportionality in the number of black people in prisons in England and Wales than in the US. One of David Lammy's biggest concerns does relate to young people, and again to quote, minority ethnic children make up a growing proportion of those offending for the first time, reoffending and serving custodial sentences. Today, 41% of under 18-year-olds in custody are from minority backgrounds, compared with 25% a decade ago. Of course, there's no single explanation for the disproportionate representation of black and minority ethnic groups. For example, we could look at arrest data. And if we do look at arrest data for 2014 and 15, it shows that arrest rates were generally higher across all ethnic groups in comparison, minority ethnic groups, in comparison with the white group, but twice as high for black mixed ethnic women and 3 times higher for black men. Of course, there are other questions as to whether or not this reflects crime rates, actual crime, or policing strategies. Other decisions have important consequences too. For example, analysis of the same 2014-15 data shows that black and minority ethnic defendants were consistently more likely than white defendants to plead not guilty in court. We know that admitting guilt can lead to the discounts, and in some cases can lead to a community penalty rather than custody. Analysis of sentencing data, I think, is equally problematic, even with sentencing guidelines. Sentencing data from 2015 shows that at the Crown Court, black and minority ethnic defendants were more likely than white defendants to receive prison sentences for drug offences, even when factors such as past convictions are taken into account. Despite some areas needing further study, and I would say in particular aggravating and mitigating factors, for example, there's currently no evidence-based explanation for these disparities. All of this, I think, leads to what David Lammy refers to a trust deficit. And he talks about the importance of trust, having faith in the system, having a perception of consistency in sentencing and so on. All of it is important to the legitimacy of the criminal justice system. Well, my question is, how far have sentencing guidelines actually helped? Have they enhanced legitimacy? What about women? I'm not someone who advocates for a separate sentencing system for women, nor do I support differential sentencing between men and women within the same sentencing system, but we're repeatedly shown evidence that a high proportion of women are imprisoned for non-violent offences, 85% in 2016, according to Ministry of Justice statistics. Most women are sentenced to very short sentences. 70% of the women 70% of sentenced women entering prison in the year to December 2016 were serving 6 months or less. I think this number has grown significantly over time. I think 20 years ago, only a third of women were given these very short sentences. So what do the guidelines say about women? How far does the definitive guideline on the imposition of community and custodial sentences, for example, help? when one of the points is, one of the questions in the guideline is, has the custody threshold been passed? And there is a point suggesting the clear intention of the threshold test is to reserve prison as a punishment for the most serious offences. Well, the evidence doesn't support the claim that doesn't support the idea of prison being reserved as a punishment for the most serious offences. The Sentencing Council's statutory duty is in section 120.11 of the Coroners and Justice Act 2009, and we learn that the Council must have regard to the following matters: sentences imposed by courts in England and Wales for offences, the need to promote consistency in sentencing, the impact of sentencing decisions on victims of offences, the need to promote public confidence in the criminal justice system. I think the David Lamming report questions that. The cost of different sentences and the relative effectiveness in preventing re-offending. So again, my question here is, how far do the Sentencing Council guidelines reflect consideration of the relative effectiveness of preventing re-offending, the sentences? How does the Sentencing Council look at the relative effectiveness of sentences? What measure of effectiveness is used? Reconviction rates, or what the Ministry of Justice puzzlingly call re-offending rates? And I ask this question when both the academic world and world of practice is very critical of these kinds of single measures, arguing instead that we need to look at changes in patterns of individuals' behaviour. Have offenders committed less serious offences than hitherto? Have they slowed down? Are there other signs of progress in terms of developing a less chaotic lifestyle? And in producing the guidelines, is the Sentencing Council aware of the relative effectiveness of community penalties and short prison sentences, with community penalties showing lower reconviction rates? So at what points and in what ways does research evidence on what works feed into the development of the sentencing guidelines? I think we've come a very long way from nothing works claims in the 1970s to what works and in what ways and with whom. We have innovative meta-analytic studies looking at reasoning and rehabilitation, cognitive and behavioural approaches, so on and so forth, suggest that certain programmes in the community in particular can reduce reoffending, and I do mean reoffending rather than reconviction at this point. Making another general point, Professor Roberts acknowledges that a Sentencing Council guidelines can and should undertake a constant review of sentencing practices. And my big question here is whether the Sentencing Council has really done this. Is the work of the Sentencing Council really evidence-based? I can think of one or two really impressive pieces of research, one on drug mules, which you mentioned, which resulted in a good change. And I'm sure that the Sentencing Council research unit is very constrained by a lack of a proper research budget. I think it does good things with the very small amount of research funding that they have. But who actually knows about the research findings? How does the Sentencing Council communicate the findings from the research? It seems to me that it remains hidden in many ways. Second question here is whether the Sentencing Council really does proper consultation. We hear about pilot studies and so on, and I think that's very important. But some of the consultations only allow 6 weeks for responses, and I think that is very difficult, and the consultations are not widely publicised, or at least not as widely publicised as some of us would like to see. So, I think that the guidelines are important, but I very much want to say that they're necessary but not sufficient. And I think that we need to look at the broader context in which the guidelines are developed and implemented. I want to say something about the training of judges and magistrates and whether they should spend more time trying to understand the sentences which are imposed, visiting prisons, understanding the realities of community penalties, becoming aware of the lack of accommodation, and so on. I wonder too how far the sentencing council, and indeed the guidelines, take account of some of the developments in relation to problem-solving courts, and my question is how far the guidelines actually help in problem-solving courts, which seem to be very positive. At least some of the research findings are very positive.